Call the special call meeting to order. Tuesday, August the 1st, 2006, at 5:35 p.m. Councilwoman Bell is present, Vice Mayor Losner, Councilwoman Waldman, Councilwoman Garner, and Councilman Porter. Order of business this evening is the future of our baseball stadium. Chairman Waldman.
Yes, thank you, Mayor. We've had many workshops, we've had many discussions on the baseball stadium, and the time's come that we either need to vote it up or vote it down, whether to sell the baseball stadium and the surrounding acres or to keep the baseball stadium and the surrounding acres. It's my opinion that we're in a different world. I mean, we've had a lot of development, green space is scarce. I think, and I put it on the record before, I think that we should keep the stadium and the surrounding acres in the city, but it's up to this council to make that decision. We've had, this afternoon, I got another proposal from Mr. Rourke. I received a proposal from the Speedway, not to purchase, but for the parking situation. But until we decide whether or not we're going to keep it or whether or not we're going to sell it, we really can't entertain these offers. So we have several things on the table tonight. If we vote to keep the stadium and keep the surrounding acres, then I would entertain another motion that you allow me to order a special master plan on creating a recreational regional area for the citizens of Homestead there at that particular site. If we decide to sell the stadium and the surrounding acres, then we need to entertain a motion to put this out on an RFP so that we will have done the process correctly. And at that time, we'll sit down and we'll negotiate. I think we've talked about everything over and over and over, and I feel quite certain I don't want to spend a lot of time on it. I think, first of all, we do need to decide if we're going to keep the stadium or not. So, okay, with that being said, any questions or comments?
Madam Chair, may I ask a question?
Yes.
I guess this would be to Mr. Sirota. You know, Joe, there's been in this proposal, I don't know if the managers had any opportunity to look at it or you either, but there's a question of the mitigated properties, and that, I mean, there's the unknown. I mean, to enter into an agreement that would possibly talk about a future of changing the mitigation status of some of the 530 acres is really an unknown. And that's really a critical component. And, you know, to give up the baseball stadium today, to possibly look at some mitigation responsibilities being taken off of the 530, what's the likelihood of that, in your opinion?
Councilman, I'm not familiar with that. Are you familiar with the mitigation issue?
Okay, I'm not sure. The proposals that I was given don't address any mitigation.
This was at the 11th hour. This was today.
Oh, okay. I haven't seen the proposal, but I don't know enough about what they're proposing or what we can or can't do. We can't do anything with the mitigated property at this time. Whether they could effectively arrange a swap, you know, I really couldn't tell you.
Okay, well, when we go back to some of the previous meetings, and even when we did a master plan for the Parks and Recreation Division of the city, and that master plan said we were somewhere in the neighborhood of 80 acres shy of parklands to the east and somewhat similar to parklands to the west. So, you know, to give up something, you know, the bird in the bush is better than, the bird in the hand is better than the bird in the bush concept. So I'm worried about going forward without some concrete replacement for properties that may be given up, because I'm under the impression that the mitigation on the 530 acres is somewhat substantial. So, I mean, if we don't have an answer to the question, we don't have an answer to the question. So.
I don't.
Well, I understand, but let me, you know, I'm looking at, obviously right now, at the staff. No, I'm not being critical. I'm just asking a question, because of the contentious part that I just see is going forward without something that tells me we could replace something that we give up. That's my concern.
Well, as far as being able to, this will be the third party, so to speak, that has indicated that they feel they could get property unmitigated. There is a mitigation bank. There is a process that happens. I don't know whether, I don't know what the cost is or any of the details would be. I think that's where you negotiate with South Florida Water Management and that kind of thing. But that is a potential. It appears from like 3 offers we've had on that land. So to do that, people seem to think that they can make that arrangement. I mean, we've all talked about it, nobody's actually gone and done it, but that they could have some kind of arrangement like that, and buying land elsewhere, donating money to buy land, sensitive wetlands that they value more than what's mitigated out there. So.
Well, in the first workshop or discussion where we were trying to get a consensus, you tried to purchase somewhere in the neighborhood of 80 acres just because you wanted to see if anything was available, and you could not.
That was it was outside the urban development boundary. It was kind of north of the track, and that land out there at that time, and we were really dealing with a person who owned a lot of land out there, and they were not willing to do that.
So at this particular point, if there's no, up to when you tried last time, we had no availability for property that could be bought in a large chunk like that.
Well, but actually the people we asked, there's other people out there, but that group that we asked were not interested in the deal that we were trying to put forth. There is other land out there, but it probably wasn't what we really needed or wanted at that time. This particular group had where we thought it would be a good place to have it, or an acceptable place to have that land. So we didn't go to anyone else at that time.
Okay, thank you, Madam Chair. Any other questions anybody has?
Any other comments or questions?
Councilwoman Waldman, yes. Thank you. I think this has kind of been batted around back and forth for quite a long time, and the more I think about it, when we did have a big discussion about this about 18 months or so ago, and while I don't think it comes any better than the IMG Sports Academies, they are top-notch, and I know that they're very, very successful in Bradenton, and many communities build themselves around an academy such as this. And with all due respect to the academy, and I give it my highest regards, I think that we don't have another piece of land that exists like this. It is 120 acres, it's contiguous, it belongs to the citizens of Homestead. I would be very hard-pressed to sell this for any amount, quite frankly, at this time. It is just a great piece of land. And I've thought about this because like I said, I do think the IMG Sports Academies are fabulous. So I kind of go back and forth on this because it would generate a huge revenue stream into the economy as well. But then again, there is not another piece of land that exists like this. And I really think we need to hold on to this jewel, if you will, this little jewel in the city of Homestead, and turn it into a huge, wonderful park that would accommodate all the citizens in the city of Homestead. And so I would agree with Councilwoman Waldman, and I think that this is exactly what we need to do with it. We have a great Parks Master Plan that was done. It's a very, very lovely plan, and I think we need to go ahead and utilize the plan that we already have, that we've already paid quite a phenomenal amount for, and let's go ahead and take the advice of this Parks Master Plan. Let's use it, and let's go ahead and do a wonderful facility for the residents of the city of Homestead on the east side. Thank you. Thank you, Councilwoman Waldman.
Thank you, Madam Chair. First, I want to echo some of the sentiments that some of my colleagues and Mr. Ivey have had at prior discussions, and it is regrettable that we do not have another parcel more appropriately suited upon which to accommodate the IMG proposal. But we don't. And I don't need to address the pros and cons of the IMG proposal to get to where I need to be. For me, it's policy and it's philosophical. We own it, it's our asset, and it is virtually irreplaceable anywhere at any price. And I would hope that as we go through the master planning process that's specific to that, that we look at all potential uses and joint uses, bearing in mind the traffic impact to the community, AQ's issues, all of those issues, so that we get the most bang for our buck and anybody else's buck that may be involved there. So for me, it's a policy question that for me is answered that we don't need to sell it, we don't have to sell it, and let's make it a true gym for the entire community. And that's my position. Thank you, Madam Chair.
Thank you. I think we're all on the same page here. I don't think we could have enough, there's no such thing as too much parkland, and the east side is definitely lacking right now. And I'd really like to see this master plan, but I would like to help, and I would like the youth council to help, and possibly, I really would like to see a youth center there, so if we can incorporate all of that, it would be great.
Making notes. Thank you, Ms. Gardner. Tom?
Madam Chair, let
yes,
me
sir.
make a few comments. I think in my State of the City address, I talked briefly about the future of Homestead and the need for open space, the need for green space, the need for preserving our parks and improving our parks. And I think we are at a unique stage in the development of this comprehensive plan to do exactly that, to preserve, and I'll say it again, to preserve the 530 acres for future generations of Homestead, and to find a way that we can take full advantage of the baseball stadium. We need a partner to help maintain it. We need a partner to come in and create programs and activity at the baseball stadium. But certainly to continue the stadium as a major asset to the people of the City of Homestead. I think it's critical. It's critical today. It will be even more critical in the future. So that's my position. I think we are all on the right track with this, and you don't know how valuable an asset is until you let it go. So I do think we need to preserve the 530 and to do whatever we can to bring the stadium back to life. We need to put some money into maintenance and improvements, and I'm sure there's somebody out there will join us and bring some quality programs to the stadium, and that's what I'm looking forward to. Thank you, Madam Chair.
Thank you, Mayor. That's exactly what the master plan would provide for us. I know the parks that I visited throughout the state of Florida, there were many instances where there were schools and youth centers, even senior centers surrounding parks, making the park the central activity. And we certainly have enough acreage out there to do many different things. As far as the partnerships, we knew that many years ago. I met with Dade County Superintendent of Parks, and I had her come down here just to look and give me her opinions, and she said, we'll never be able to do it unless we enter into private partnerships. So all those things, sir, would be certainly looked at in the master plan process. But before I can ask for public input, do I hear a motion on the floor?
I'll move that to retain this site.
I'll second.
A motion made by Councilwoman Bell and seconded by Councilwoman Gardner.
Not to sell.
Not to sell.
The motion is not to sell, and is it direction to the staff not to entertain further offers?
The maker of the motion?
I'm just asking, is it?
Well, I think that precludes that. If we say we're not going to sell it, then that would preclude that we're not going to accept any further offers.
Okay.
Yes.
Well, you could change your opinion about selling, but okay.
Okay.
All right, so the motion is that we do not sell the stadium and surrounding acres, and we do not entertain any more proposals. Any other comments from the audience? Public comment? Any comments from the dais? All right, I'll take a vote. All in favor? Aye?
Aye.
Aye. Any opposed? Motion carries. Now, I would ask that we entertain a motion to allow me to move forward with a master plan.
So moved.
Second.
Made by Councilwoman Gardner, seconded by Councilman Porter. Any comments from the dais?
Question.
Question.
How would it incorporate into the existing master plan in some way, or is it a freestanding master plan?
A freestanding master plan. The existing master plan touched brief, and Marlene, you might need to help me here, and Kirk Herron, but as I recall, the original master plan, it touched briefly on the stadium and the surrounding acres and gave us some ideas, but what we need is an in-depth study, and we need to study parks from all over the United States. I mean, we saw some beautiful parks in Chicago, and we certainly have enough acreage there that we could make this, we could just make this state-of-the-art. So that's the kind of master plan I'm looking for.
But they'll incorporate the existing master plan into the one that we would be looking for.
And Marlon, correct me if I'm wrong, there's really very little on the stadium itself, because at that time we didn't know, it was always so up in the air, and we were still looking at proposals, and finally I just said, look, we either need to vote this up, vote this down, and then move in whatever direction we need to.
Thank you.
But we will incorporate the old master plan into it.
Thank you very much.
Any public comments on the master plan? Any other comments or questions on the dais?
Please.
Yes, ma'am.
I want to go back to something the mayor said on the previous motion and discussion that we need a public-private partnership. And in that regard, I want to jump over to the master plan issues that I would hope that we would be open-minded, and certainly I would want to know, and whoever does the master plan for us, that if in their opinion one or more of the existing buildings needs to go, so be it. That if we need the blank slate of raw land, so be it. Some of the successful partnerships that I've seen in other communities throughout South Florida are parks tied in with educational components and pools, tennis courts, basketball courts, all of those things, and I hope that we give whoever does that we're all in consensus here that we're not foreclosing any good or appropriate idea from inclusion in that master plan. I think we do with that potential master plan have the ability to kill more than two birds with one stone, to meet many of the needs, and obviously, as I said earlier, we're going to have to be very sensitive to make sure that we've addressed the traffic issues for East Homestead as well as AQs and the other military issues there. And just that we can all be bold enough to sit down and take a real good faith look at that and not out of hand dismiss any idea before it's really analyzed.
I agree, Vice Mayor, and I also want to take this a step further. We have talked for years now as to what is the real condition of the baseball stadium. So I am hoping that the company that we do hire, which of course we'll put, do we have to put that out on an RFP as well? I'm glad Jackson is so familiar with our area and is working so closely with us in Lawson Park. But do we have to put that out on an RFP for the master plan?
We may have someone already in our RFPs that we've already approved, so it would not require another RFP.
All right. Well. Anyway, the point that I was trying to make is that Vice Mayor is very correct. I mean, it's time we learn what needs to be done to that baseball stadium. What needs to be done. We need to have inspections, proper inspections. Not just guessing. Okay, maybe we need to fix this over here. We need to have an inspection done, and it needs to be a thorough inspection.
Or, Madam Chair, if I might, or if we even need to spend the money to put the stadium back in the condition it was in. That was built for Major League television broadcast games.
That's true.
And, the level that was there may not be necessary or appropriate to spend that money.
And I promise you, as we start the master plan, if it passes tonight, if we start the master plan, we'll have many, many workshops, just as we did with the parks, the existing parks in the city of Homestead, and we'll have input from all of you, and we'll take surveys, and we'll have meetings, and it's a long process, but it's a process that's long overdue, and we need to start it. Thank you. Any other comments or questions? No? Any comments, or I think I already asked this, comments from the audience? No. All right, I'll take a vote now. I think the motion was made by Councilwoman Gardner and seconded by Councilman Porter. All in favor, please respond with aye. Aye. Any opposed? Motion carries.
Thank you, Madam Chair. You have the green light to move forward.
Thank you. Well, we're ready.
Item 3B is a motion to authorize representation for Councilwoman Bell in the lawsuit Redland Company, Inc. versus Linda Bell.
And Mayor, I'm going to have to vacate. I was told by Council Joe Sirota that I can take no part in either the discussion or the vote because of the Ethics Commission has stated that I cannot. So I'm going to abide by that, and I will be right back here.
Thank you, Ms. Bell.
Mr. Mayor, do you want me to comment on that while Councilwoman Bell is leaving? The issue is whether or not Councilwoman Bell could vote on the motion that you just described. It's not a simple issue. Ultimately, our office were in touch, our attorneys in our office contacted the Miami-Dade County Ethics Commission. Robert Myers, we spoke to specifically. He was in touch with the chairman of the Ethics Commission, Kerry Rosenthal. After considering all the various issues, which I'll spare you unless you want to know, ultimately they advised us about 3 o'clock today that it was their position that Councilwoman Bell could not vote or participate in any way on this vote. And according to Section 2-11.1 of the Dade County Code, it says that the councilperson shall absent himself or herself from the meeting during the discussion of the subject item and shall not vote on or participate in any way in said matter. And Councilwoman Bell has indicated that she would comply strictly with their advice, and that's why she left, and that's also why before she left she did not make any comment whatsoever about it. That was our advice to her.
Well, thank you, Joe. In reference to the representation, could you state the law on this? Because I know some people are a little confused, but we have the right to move on authorizing the representation.
Yes, Mr. Mayor. Under Florida Statute 111.07 called Defense of Civil Actions Against Public Officers, Employees, and Agents, this is a statute that applies to all elected and appointed officials who are sued in a civil matter. Councilwoman Bell has been sued individually in a civil matter. If she has been sued in a matter that has arisen out of her duties, then the government, under certain circumstances, would provide defense. Now, we have all previously determined that the nature of the lawsuit does stem out of her official duties, so then it falls right into 11.07. The issue before the council today is whether to authorize an attorney to defend Councilwoman Bell at this time. The City Council has absolute authority under this statute to do just what the motion provides for. However, the City Council has a choice. That is, you can authorize and provide her an attorney now, or she can obtain her own attorney, pay her own fees, or whatever arrangement is with the attorney, and if she prevails, then she is entitled to be reimbursed for all of her fees, or for a reasonable fee and her costs. So the question is, do you authorize and provide an attorney now, or do you say that she's on her own, and if she prevails, she can come back and get reimbursed? Let me just, if I can, on behalf of Councilwoman Bell, perhaps suggest an amendment to the motion. Councilwoman Bell has contacted an attorney, Ira Elegant. Ira Elegant is a well-known attorney in Miami to represent her. So what she is asking is for this council to authorize, well, it says, according to the statute, is authorized to provide an attorney. She would like to use Ira Elegant as her attorney. Now, he charges, or he's willing to charge $400 an hour. His regular rate, I am told by Councilwoman Bell, is $450 an hour, but he will charge $400 an hour. So the motion would be to authorize Ira Elegant at $400 an hour to represent Councilwoman Bell in the lawsuit Redland Company versus Linda Bell.
Thank you. Any questions?
I have a question. Go ahead, Mr. Vice Mayor.
Mr. Vice Mayor?
Mr. Sirota, if we were to go forward tonight and authorize her to retain the attorney at the city's expense, and you and I know there's a fine line here between who's the client and who's paying the bills, would it be incumbent upon us, or, as prudent as the bill payer and not the client, to set an initial allocation of money toward fees and costs and have some sort of periodic update or status report such as your firm gives to us on city matters? Would that be an appropriate part of the situation?
I think that would be appropriate. That would also be a way for you to be aware of what your bill is, and to the extent that you wanted to adjust your direction in some way, you could do it. The statute provides that you are authorized to provide. So as you were saying, Mr. Vice Mayor, there would be a retainer agreement between the City of Homestead and Ira Elegant, but it would provide that the client is Councilwoman Bell, and that's where the privilege would be. We would just be the payers.
Right. And I don't know, in my time here, I don't think this has ever come up. Would you anticipate that your firm or someone would review the bills to ensure that that there's not excessive time being spent for what's being accomplished?
Yes. I mean, we're responsible for your legal affairs just like we review bills of attorneys not in our firm. We would do the same thing here.
Now, I guess finally, you answered one of the questions that I had anticipated asking that I think is very important, because, there's probably, two equal schools of thought out in the community, and then people are here tonight saying, well, if you're sued, that's your problem. But you've answered my question that this lawsuit the allegations of the suit are predicated upon actions that she allegedly took in her capacity as a city councilwoman, which puts us into the statutory provision. But the suit arises out of official actions?
Yes, that's really what I would say, because, the next step, we're not prepared to give an opinion on. There's allegations in the complaint, no depositions have been taken. What we are saying is that the allegations of the complaint, at least as we interpret this statute and as it's been interpreted, does appear to arise out of and in the scope of his or her employment or function. Mm-hmm. Now, if depositions and proof during the course of this case somehow establish that her actions were not within this scope, then she would not be entitled to reimbursement. Mm-hmm. And in fact, the opposite would be if we came up front and we paid it. Under this statute, she might be liable to us. But at this point, it appears that it's within the scope, unless we're proved otherwise.
Right. Now, let's say that at some point in the future, she and her attorney prevail. Who has the right then to pursue a claim against the plaintiff for reimbursement of attorney's fees? Is that her right, or is that the right of the City of Homestead to pursue reimbursement for prevailing in the suit?
You're saying to the extent that there is an opportunity for reimbursement?
Opportunity to pursue the plaintiff for recovery of the defendant's attorney's fees.
Well, since we've employed the attorney, we are out of pocket. It would seem to me that we would have the right to seek reimbursement.
So we do have that. I mean, it's not split.
To the
She's the
extent-
client, we're the bill payer.
Correct.
It would be our right to...
I believe it would be our right, but of course, there's no clear entitlement here that we
Well,
would have.
absolutely, that's
to
way
reimburse.
down.
Yes.
Way down the road, as we know. Well, certainly my perspective would be is this could be any of us, and people have sued us in mass before over certain charter votes and I think some zoning votes, and it could be any one of us. And from where I sit, at $400 an hour, a grant of fees after the fact is tantamount to denying fees, and certainly that I would support the grant of a definite amount up front to be allocated fees and costs. And we have the opportunity as the case progresses to decide how much deeper we're going to go. But I think it could be any of us, and clearly our attorneys have stated that it appears that the allegations of this suit fall within the parameters of the enabling state statute. I would be supportive of allocating $12,000 in fees up front and $3,000 toward cost. I mean, some of you may have an idea of how much court reporters are for each session, each deposition. It's mind-boggling what those expenses are above and beyond the fees. So, Mayor, if you're ready to accept a motion, or if you want to have further discussion.
I'll come back to you, Mr. Vice Mayor. Any other comments, Porter?
Well, I had a question, between what the Vice Mayor talked about and what Mr. Sirota talked about, answered some of the questions. But you're saying, Joe, based on the statute, we really have no recourse but to pay the fees, whether it's up front or whether it's recovered, right?
I'm saying that if she prevails, you have in my opinion, you have no discretion except to pay a reasonable amount. The discretion occurs, Councilman, now. That is, that at this time, what the statute says is that you are authorized to provide an attorney to defend any civil action, but you are not. It is not mandatory that you provide it at this point. If she prevails, then she is entitled to to be reimbursed, as long as the facts establish that she was acting within the scope. In other words, as long as she was acting within the scope and the court determines that she was acting within the scope, then it is, in our opinion, mandatory that you reimburse her for a reasonable fee. And there could be an issue as to what a reasonable fee is. That's what the statute says. At this point, though, it is discretionary on your part. You are clearly authorized to do what the motion provides, but it is discretionary. It is not mandatory that you do it at this point.
What about a settlement? How does the statute talk about if there's a settlement in the case?
It doesn't. That's an excellent question, and there is no clear direction. In the event of a settlement, I would expect that the elected official would say there was no proof that I acted outside the scope and therefore reimburse me. Theoretically, the council could claim that there was no ruling that it was in the scope. So I think that there would be some gray area if there was a settlement, but it would seem to me that if there was I really can't speculate. It doesn't speak to a settlement. It only speaks to prevailing or not prevailing.
That has bearing at some point in time. That has bearing on the whole issue. Mm-hmm. At this time, I'll let any other questions. I got to think through some other things too.
Any other comments, Ms. Wellman?
I have some very serious questions, Joe. And I'm going to have to direct him to you because Richard's not here. And Richard was the one that sat here before us. I can tell you that I feel like I have not been allowed to speak. I feel like I have been, I was advised by the city attorneys that it was best for the best interest of the city that I remain silent. I've had my mother, I've had my friends, there's many of you out there in the audience who have begged me to step forward and talk about things. I've had phone calls all weekend and all day today, we begged you to talk. And I haven't talked, and I know, sitting on the dais, that there were 3 or 4 different instances when Richard informed us that that was not a good thing to do. And I remember one time when Mr. Hodge was speaking, he stopped him in the middle of his comments and said, that is not a good thing to do. And we all had the same advice. Is that not correct?
That is correct. Because
I can tell you, and I don't know if Richard has told you, but I've called him repeatedly and said, when can I speak? When can I talk? Because in my opinion, nothing has changed. The contract was terminated. It was a unanimous decision. It was terminated. It was never reinstated. And I don't understand. I quite frankly, if I could ask Ms. Bell this, I would ask it to her, but I can't, as you all know. I just don't understand why she took it upon herself to go out there and talk and write editorials, really saying terrible things. And it was awful because we were not allowed to speak out. I remember one editorial that was written, and the mayor, I'm not trying to speak for you, Mayor, but the mayor wrote back an editorial, and I read his editorial, and even in that editorial it said, we can't talk about things right now. In due time, we'll be able to speak. But instead, what had happened? Ms. Bell wrote another editorial to the paper. And then there were other people that wrote editorials that obviously had information fed to them. So I don't know. I'm conflicted. And let me just say this. To me, this should not set any precedence, because if you did what you were instructed to do by council, and you knew what was right and wrong, and yet you went out there and did not put the city's best interests first instead of your own, then I'd be the first one to make the motion to defend you and to put the money up front. Now, I have no problem reimbursing Ms. Bell at the end of the day if she's exonerated. I hope and pray she is. I really believe that. But it's my taxpayers' dollars, it's your taxpayers' dollars. And I know I hope the other council members speak out, because I know for me it was hard. It was so hard when friends and family and even citizens that I didn't even know would stop me on the street at my Greenway project meeting. Judy, why aren't you speaking out? What is wrong with you? And I would say, I'm sorry, I can't talk about it right now. I'm sorry. At a Seminole Theater meeting that I attended, I get together, people said some terrible things to me because they said I wasn't brave enough to speak out. And I said, you know what? I was instructed by council that we pay a lot of money to, that it would not be in the best interest of the city. So that's how I have to look at this tonight. What is in the best interest of this city? And again, if any member of this council, including Ms. Bell, follows the rules, even if you make a mistake and you don't mean to make a mistake, you don't do it intentionally, but when you go out there and you put your name in editorials and you go out there and you know that there's talk everywhere, then I can't support it.
Thank you, Ms. Waldman.
Mayor? Go ahead. Well, Ms. Waldman, I'm glad you brought all that up, because I've been frustrated as well, thinking along those same lines, that it could happen to any of us, but when I have questions, I call the city manager, I call the attorney, talk to them privately. It was very concerning to me to see information given directly to the newspaper. I've felt that since some of those editorials went out, that the city was put in exposure because of them. And bad things were said about myself too, and it was hard to sit there and listen to it and not say anything back because I was afraid it was going to affect the city's outcome. That aside, I'm just concerned for the city's benefit. To go ahead and do this, I don't know that it's within the scope. I don't see it as my job to go out there and do investigations. I think that the staff is knowledgeable and they can do their own job, and if we direct them to do something, they're going to do it. I don't feel a need to go out there myself and make that my agenda. So I don't know that this was in the scope of the city. I'm very uncomfortable with this. I was very upset the other night when it was given to us and thrown in our laps and told us, yes or no, what are you going to do? I didn't even have time to read it. Now that I've read it, I'm quite concerned. I'm quite concerned that she acted out and has put us in a liability situation. So I don't know that I can do that. I don't know that I can support that. If she were to be exonerated, yes, I would fully support reimbursing her. But I'm not a judge. I don't know what a judge is going to look at and say. You're right, we wouldn't have a choice. But I would be, if that were to happen, I would be glad. I'd be glad to reimburse her. But I'm not an attorney, I'm not a judge. I look at the case and I say, wow, that really doesn't sound like something that you should be doing. Your staff should be doing that. And to make it such a public issue, and we've been told 4 different times at public meetings not to talk about it, that's hard for me to take.
Mayor, I forgot to say one, if you're finished. I'm sorry, I need to mention this. In the suit, there is an email that is written by a gentleman that filed ethic charges against 5 of us on this council. Timeline is there. I'm not going to go into it. It's public record. You can look at it. But I'm going to tell you something. This is serious. I was out of town last week for city business and came home to slash tires in my driveway. So I'm not fooling around here, I mean, there's problems, and I'm not accusing my finger at anybody. I'm just saying, as public officials, you're a target, and people can say and do whatever, but we must respect one another on this council, and we must agree to disagree when necessary. But you still have to have respect for one another, and I just wanted to put that on the record. Thank you.
Thank you. Were you finished, Ms. Gardner?
Yes, Mayor. Thank you.
Mr. Porter?
I guess one more question I'd like to speak to the attorney, because I don't understand completely the timeline and the process with this. Obviously, we're not here to, I certainly agree with a lot of what was just said, because we've all been under an attack and we've all kept our mouths shut. And there's been some real ill feelings that have come out of this. But that being said, she's going to be defended. Are we going to get drawn? We're going to get drawn into this anyway as a city. We are going to get drawn into this. You say this statute here says she has the right to be defended by or paid for, right? We're drawn into this.
Well, ultimately, if it's deemed it's within the scope of her responsibilities, then we have to pay. That's what the law provides. But when you say that we will be pulled into it, that may be the extent of which we're pulled into it. Now, whether or not, when the litigation gets going, there's depositions scheduled which have to, maybe the manager's deposition is taken or theoretically one of yours, although that would be unlikely, that might be another way in which the city could be pulled into it. But when you say being pulled into it, as I see it, the only involvement would be providing an attorney now or reimbursing Councilwoman Bell in the event it is deemed that she's within the scope at the end of it. That's the only way the city is involved at this time, unless depositions are taken and things like that, pull you individually or staff into it.
Okay, because at this particular point, the suit has nothing to do with the city, because the alleged issues have to do with what was done outside the scope of her position as a city. That's what they're alleging. No?
Not
yes.
Exactly. But the lawsuit is against Councilwoman Bell. It is not against the city. Part of the lawsuit is that she acted outside of the charter. That is one allegation. Another allegation relates to some alleged civil rights violation. But it's not clear as to whether the entire case is based upon her acting outside the scope or not. I didn't write it. I don't know what's behind it. But there are allegations that, if proven, could demonstrate that she acted outside the scope or not.
And if she's outside the scope of her function as a city council person, then we would be reimbursed, the city would be in a position to be reimbursed for anything that it put into the defense.
Correct. That's what the statute provides.
How long would it be before we would find out? Is that in some sort of a preliminary hearing, or is that going to be at the very end of the hearings? Or
that would be at the very end of the hearing, and chances are at the end of the appellate process, if there is one. It could take quite a while.
It's very difficult to sit up here and talk about this. It's not a fun place to be, and you have to sit up here and make these decisions based on all the facts. You have to talk about things that are uncomfortable, and I don't know what the answer is, but I would hope that whatever comes out of this, that whoever sits at this dais would learn a lesson, or anyone in the future would learn a lesson about how we take the position and at least adhere to some of the advices of at least the legal side of the equation. We can have differences of opinion with staff and management, but legally we have to be careful, and I would hope that there would be something learned from this, because we have been over and over and over again advised not to talk about this. I'm surprised we can talk about it as much tonight, except for if Richard was here, he'd probably cut us all off again.
Well, you haven't spoken about any substantive issues. I've been listening.
Well, it's a difficult question. I wanted it, in my mind, to be able to make sure that the city would be separated out, because until there's some sort of clear definition as to scope of operation, what is the scope of a political position in a manager form of government? And that's unclear at this point. So, go ahead, Mayor. I'm sorry.
Thank you, Mr. Porter. Well, I think I appreciate all that's been said thus far from each of you, and I have a tremendous amount of respect for all of you. But we are in uncharted waters here. As I think it was mentioned before by the Vice Mayor, that this have never happened in my 25 years of service. And I have to really look in the soul of an individual and make a judgment call as to what is right and what is wrong. And I take the position that Councilwoman Bell have always tried to do what is right. And I think sometimes when you try and do what is right, you make mistakes, and we all do. But I think because we are in uncharted waters, and this is the first time we've been confronted with this issue, that we need to support her. I think this issue has been one that, and I've stated many, many times, will be settled in court, where it belongs. It can't be settled here. It can't be settled with comments back and forth in the community. We have taken a legal position, and it's in the hands of a judge and a jury. And hopefully we will prevail. But at this juncture, we have a unique situation here. I think I will take the position, I really feel as if Councilwoman Bell was acting in her capacity as a councilwoman and felt that her position was the right position. And as a result of that, I would ask that we support her and let this be a learning experience for all of us, that in this business, we have to make some tough calls sitting up here, right or wrong. I will take the position, each and every one of you, when you do make a decision, that you do it not only from your conscience, but from your heart, and what you think is in the best interest of the people of the city of Homestead. And I'll stand with that for Councilwoman Bell. I think that she did it from her heart and what she felt was in the best interest from her point of view with this situation. And I think because this is the first time and we are in uncharted waters, that we need to give her a chance and support her on this issue. And I will now accept the motion.
Mayor, I'd like to ask our attorneys one more question before I make the motion. Joe, there's been a lot of conversation tonight about some feeling that maybe she brought it on herself after being advised not to talk about the pending Redland suit or some of the events that gave rise to the suit. I just want to pick your brain. My understanding of reading the suit is that a portion of the suit may go off into those areas. Would it be your opinion or your understanding, though, that there are portions of the suit that are not based upon her public pronouncements or activities, that there are certain other allegations that don't deal with publicly talking about the suit? And let's split hairs here for a minute. I think that the cautions to us have been not to discuss here in a public of record meeting the ins and outs of a suit, or he said, she said. I don't know that anybody was ever advised, and don't go write letters to the editor and don't go write editorials. Might have been bad judgment, and I'll kind of stand with the mayor that while some of us may have problems with her tactics or strategy, she believed that her position was the right position, and hindsight's always a good teacher. But aren't there some other allegations that don't fall within the she shouldn't have gone off and talked after being advised not to?
Well, you've asked a series
like
of
violation of charter and some of the allegations I think can count to about talking to other agencies.
Yes,
which would not fall within that public caution.
Well, let me start by saying that we can all read the lawsuit. I didn't write it, you didn't write it, so in terms of interpreting it, it's a little bit difficult for us to do. It does appear that all of the allegations relate to a matter that did appear in front of you. The subject matter of the lawsuit does relate strictly to subject matter that you all considered. Now, whether the allegations as to what Councilwoman Bell did, and again, these are pure allegations, might fall outside of her scope, I think the answer is probably yes.
I wasn't asking about scope. I was asking more in terms of when we're cautioned by your colleagues in public forums, public meetings, strictly defined public meeting, not to go off into certain areas of discussion. I don't know that it's ever been clarified, and that means you shouldn't write letters to the editor, and you shouldn't write editorials, and you shouldn't talk about it in neighborhood meetings. Is that a fair distinction, or?
Well, what we've done since Mr. Weiss is not here, he's away this week, is we've gone back over the minutes, and we've gone back over to the extent that we were able to look at the DVDs. The advice that was provided, at least what's been reported, is pretty broad. It doesn't appear to me to be limited strictly to what you say on the dais. For example, I'm looking at the minutes from January 17th. It says, City Attorney Weiss mentioned we should not talk about what the city should have done or should do right now because it could come back to hurt us. You should stay away from detailed discussion about one party or the other did. Now, the question is, was that advice strictly limited to what you're doing now when you're up there? I don't think so. I think it was broader advice, although there are some portions of it that do relate to the dais. In other words, another section of those same minutes said that because of the issue involved, meaning the lawsuit, you shouldn't talk about it this evening. So, I mean, that advice certainly did deal with the dais. Well, but I would say, to be fair, in just my readings of this, it does look like the advice was broader.
As a practical matter, isn't that more in terms of, from a litigator's perspective, let's don't throw any ammunition out there that can be used against us in the suit that's at hand?
Correct. That's correct.
Don't reveal our strategies. Don't reveal those kinds of issues.
Correct. And even tonight, I just want to make one thing that's clear. To the extent that any of you talked about Councilwoman Bell making a mistake, to the extent that you used mistake, I'm assuming that it might be suggesting that the mistake was talking about things in public as opposed to the fact that she did anything wrong for purposes of the allegations in the complaint. I'm assuming that's what the comments related to.
That's what you say we should mean?
That's what I'm certain you meant.
Yes, absolutely. Well, having said that, and I think the mayor's asked for a motion, and certainly I indicated earlier, and I want to be real clear that while my motion is going to include specific amounts, that is not intended, if it passes, it's not intended to be a limitation. It's intended to be an initial allocation. Hey, I'm one of them, and I don't think you should give any attorney an open checkbook. So, Joe's not laughing. But,
no, I'm taking this very seriously.
Yes.
Would you like me to read back your motion?
Well, you know that I ever made one, but, okay. You know, and subject to the issues that we talked about earlier, that we're entitled to periodic status reports so that we can see the progress, and you're going to monitor the bills, and that we've gotten advice that we have the right, under certain circumstances, to pursue the non-prevailing party for the recovery of attorney's fees, and non-prevailing can either mean the plaintiff or the defendant.
Well, I think the statute talks about the defendant, but there's always a possibility of being
the payer of the fees.
Right.
Yes.
There's always a possibility under certain circumstances of seeing whether or not we can go against the plaintiff for fees as well.
All right. Now, just before I make the motion, I saw something on AOL News the other day. It was the 26th. And the title of the article is "Horse's Head Dumped in Councilwoman's Pool." Of course, those of us that are old enough immediately think of that scene in The Godfather where the guy wakes up with the horse's head in his bed. And I couldn't help but wonder if we're all subject to having these suits become the horse's heads in our beds. And it's easy to make that analogy. So having said that, I will move that we make an initial allocation of $15,000 toward attorney's fees and costs as requested by Councilwoman Bell. Do we need to name her counsel of choice?
Yes.
Is Attorney Ira Elegant, with a formal fee agreement to be entered into between the City of Homestead and Mr. Elegant.
Right. Mr. Mayor, may I ask a question?
Yes, sir.
Vice Mayor, when you talk about the initial $15,000, when and if the $15,000 is reached, what do you envision would be required? An item placed on the council agenda, and to come back, report, this is where council is, he's requested another X dollars, and then you would approve it again? Is that what you're contemplating?
I had kind of contemplated that we would receive a status report prior to the exhaustion of the initial allocation, and that before the initial allocation was exhausted and we have an outstanding attorney's fee and cost bill, that we would have the opportunity to make the decision to either pull the plug or make an additional allocation based upon the the status reports.
Okay, and that would be set on the agenda, and you would consider it?
Absolutely.
Okay, understood.
Mr. Terrell, could I speak as a taxpayer, make a motion or vote on a motion?
The mayor is running this meeting.
Go ahead. It's been properly moved. Is there a second to the motion? Been properly moved. Is there a second? Well, I will relinquish my chair to Ms. Wallman, and I'll second the motion.
Thanks.
Madam Chair, can I ask a question?
Absolutely.
This is, I have the feeling this is a bottomless pit that we're going into. I still have yet to be under the clear opinion of where it is that we go with this. You know, you said that this could go on for years, correct?
Yes, it could.
Okay. For years this could be in litigation. For years we could be stuck with the cost of this, or is in the motion an ongoing series of meetings where we would have to keep throwing in additional monies to this process. And it's a bottomless pit. I mean, correct me if I'm wrong. I don't see where, because there's argument. I mean, I agree with all the arguments. I agree with what the vice mayor said and the mayor said, but there's got to be some limitation to what, you know, we open up, like's been said, open up the checkbook, come and get it.
Well, my understanding, and I don't mean to speak for the vice mayor, but my understanding what the vice mayor has moved would be a situation where perhaps before $15,000 is exhausted, or slightly before that's going to happen, that the matter would come back before you, and at that time you would have the opportunity to reconsider it. Am I correct?
Absolutely. So, you know, I don't, and that's an interesting choice of words, bottomless pit, in this situation.
Very good.
That's exactly what I was trying not to get into, was that open checkbook, that we have an initial allocation, and if we decide to fund up front and give any kind of allocation, that it's subject to further review with obviously the discretion and right of this council to say, we've thrown enough into this, our attorneys maybe would render an opinion at some point that there appears to be maybe a finding or an intimation that her actions are going to legally fall outside the scope of her activities, and we'll have that opportunity to reach that maximum depth, if you will, if we're going to have that play on words, and go from there.
Mr. Madam Chair, let me just say, that does bring, I didn't get that out of the motion, so as long as that's your intention, then to me, it's just one of those opportunities. It's a checks and balances system that we as a council can come back again at some point in this process and say enough is enough. Because that's why I would like to know at some point in time, as soon as possible, whether there is any credible argument to this suit, and so that we don't just continuously go on and on. So, based on the fact that there will be something that we can come back to at a future date with a time-specific amount of money, I could support the motion. And it's very, very, very difficult to do that. Very difficult, because I do believe, in my mind, things could have been done better. Madam Chair, I'm through.
Mayor Warren?
No, I have no comments, Madam Chair.
You wanted to say something.
Public comments.
I'm going to have public comments in one moment, but again, I want to preface my position and say that if you follow the rules that council gives you, and Mr. Sirota, I can tell you that when I called Mr. Wise and asked repeatedly, when am I going to be able to speak? What can I write something? Can I go and speak to these people? Can I just talk to my neighbor? My neighbor's in the audience tonight. She knows I didn't talk to her. I was told no, you should not do that. If you have the best interest of the city at heart, you cannot do that. So again, I want to preface that by saying that if anyone is sued on this dais and they follow the rules and they do what they think in their heart is the right thing, I would support that motion completely. With that being said, public comments. Please, you'll have a limit of time. Please step to the podium, state your name, address, and we'll have a 3-minute time clock.
Should I turn on the microphone down there?
Is the microphone on?
My name's Joe Scioli. I'm a taxpayer and a businessman here in town. And I got some concerns here. First of all, with Mr. Sirota, he said it was her official duty and she was acting within the scope. I have a big, major problem with that, okay? First of all, I've been in this city since 1969. I have never, ever wrote a letter to the editor until I read her comments consistently in the newspaper, okay? Never come to a public meeting, never. I have a big problem with all this. She's clearly fighting Teresa's battle. Everybody knows that. You have to face it. You just have to face it. She's fighting Teresa's battle. And Mr. Roscoe said, do what's right. She didn't do what's right. Make tough calls. She didn't make a tough call. She attacked people. Plain and simple. Did it come from her heart? Yeah, it came from her heart, maliciously. Okay? Bad judgment, maybe once, maybe twice, maybe 3 times, but repeatedly, give me a break. And follow the rules? I'm sorry, she did not follow the rules. I read the newspaper. I'm out of town a lot. I have been lately, but I'll be here more. I'm on the road building restaurants, but I pick up the newsletter and I see her comments, and it's sick. It's sick. It's just, it's crazy. I say let Teresa pay her legal fees. I mean, let's be honest, seriously. My taxpayer dollars? You ain't spending my taxpayer dollars representing her. Thank you very much.
Any other comments?
John Burgess, 655 Southeast 30th Drive. As a taxpayer and somebody that once tried to sit up there, I would hope that the council had the backbone to back me for something that I thought was in my heart the right thing. Maybe she did go over the boundaries of what was said and speak a little bit too much, but I would think that she was trying to act within the scope of her chair, and I think that and would hope that the city council would stand up and back her up, and that the city would too. And I know it's a very delicate situation what's going on, but I would hope, and I think that Linda thinks that she was doing the right thing, maybe got a little carried away, but I would hope that the city would back somebody up that's up there trying to work for the city and does so much for the city.
Thank you.
Angel LaRoe, 2214 Northeast 41st Ave. My feeling is that the council should support Linda Bell. Maybe she did make some mistakes. Everybody makes mistakes. It's not a bottomless pit. It's an initial amount that's being proposed, which I think is fair, and I think by the time you get to that point, you'll have a better perspective to take a look at and make a better judgment at that point. I think from the position that we're in now, it's a big guess, and I think we should err on her side as opposed to against her, because I mean that's how I look at it. You're either with her or against her, and I would hope that the council would support Ms. Bell.
Can I just comment on that, Angel, if you don't mind? I don't think anyone on this dais is against Ms. Bell. We all have said that we wish her the very best and we hope that she is exonerated. We have all said that. But thank you for your comments.
Susan Newman, 2835 Fairways Drive. As someone who is in an appointed position, I would think that, and anybody has a right to sue anybody at any time, and I would hope that if there was something that a suit was filed against me and on Planning and Zoning Board or any of you, that we would support that person and help them out with the initial amount of $15,000. You get to re-evaluate the situation at that time. So I would hope that you would support her at this time.
William T. Bell, 2835 Fairways Drive. My comments are similar. I respect all of you up there at the podium, and I feel that I would support any one of you with the same vigor, but I have a fear that you are all at a point where you're could be a victim. And that concerns me seriously. I don't, having 4 slashed tires in your driveway because you're a public official doesn't set well with me. And it could happen to any one of you. And what else could happen to you? We live in a violent time when people decide that you can't speak out. This is how you crush people. You have to be able to speak your mind and your heart, because freedom is based upon how tough or how weak you are. Thank you.
Thank you, Mr. Tebow.
Can I say one more thing? I didn't use my 3 minutes.
You didn't use all your time.
Her job is a councilwoman, all right? I believe it's police department's job and code enforcement to count trucks, chase trucks, and watch where Phil's going. Why was she doing this? How did she know to do this? Tell me. It's simple. She's fighting Teresa's battle.
Thank you. Madam Chair, may I make a comment? Just recently, the city attorney came forward and approached city council because the ethical issues that keep getting brought up to elected leadership, not just in Homestead, but across the state and all the municipalities, has become a very, very serious issue. And only until the last 3 or 4 weeks or so has there been any protections for us at this city level, at this city council, for these really unwarranted complaints, and they're very, very serious complaints, and they drag you through a very, very tough time in your life. I'm being one of them. But let me say, I've been out there on my own by myself. So when you talk about everybody's entitled to a little help, certainly I agree, but only until just recently have council had any protection and had any support from legal staff by the city's pocketbook until about 3 weeks ago or 4 weeks ago. So it's not uncharted waters when you talk about being up here, being a target, and being out on your own, because we are. And it is serious when Miss Waldman goes home to slash tires or any of the other things. It makes you wonder why you do it, because you certainly don't do it for the money. And it is a critical point for us, and I hope it gets better. But let me tell you what, I've been up here 9 years, and I've had some really serious, hard accusations, and I've been out there by myself. So we just need to do a better job. As elected leadership, we just need to do a better job. And I'm sympathetic. I hope we all learn from this. I said I would support the motion up to a point, but I certainly don't agree with and I think the Vice Mayor handled it well in his motion. But I'd like to be able to review this on an ongoing basis, because I'm not convinced that this lawsuit is a frivolous lawsuit. And certainly our attorney is not convinced. One way or the other, he's got an opinion, but he can't tell me it's right or wrong. You never do, Joe. I just hope that the community understands what we go through, how difficult it is, and we need to choose our actions very carefully. And this will cost the taxpayers in this city a sizable amount of money. And some of the complaints that have been filed against the council members up here today will cost this community a sizable amount of money. And I would hope that these frivolous, mindless accusations against elected leadership, just because we have to have sometimes a difference of opinion, it's got to stop. My opinion is mine. It's not right. It's not wrong. It's mine. And that's where we get in trouble up here. Well, let's debate the issue. Let's talk about the pros and the cons, take an opinion, call the question, winners win, losers lose, life goes on. No viciousness after that. My opinion's not right, but it's certainly not wrong. And that's where we get into these gray areas. That's where we get into these problem areas. Let's just debate the facts. I I hope things turn out well for the city in the existing lawsuit with Redland Company. I hope things turn out well in this lawsuit for the city and Ms. Bell. But we have to watch what we say, and the council position doesn't give us a stick to beat people with, and that's what we just need to be careful. So I'll support the motion up to the limits that the vice mayor set and that the mayor seconded, and then we should have the same public input when it comes back around. We'll see how much more money we're going to pour into the pot. But it does go down hard. It does go down hard. So with that, Madam Chair, I'm through.
Thank you, Mr. Porter. I just want to address those that spoke about elected officials. Elected officials have a responsibility and a fiduciary to the citizens of this town. They have responsibilities. They take an oath of office. And I cannot sit here tonight and I hear people say that it's from the heart. I'm sorry. When you're told not to speak, when you're told it's the best interest of the city not to speak, keep your opinions to yourself. Say anything you want to the attorneys, to the manager's office, do whatever you have to do. But I cannot support it. And any other public comments, I'm going to call the vote. If not, all right, I believe the motion was made by Vice Mayor Losner and seconded by Mayor Warren. And please read the motion again.
It is a motion to authorize Attorney Ira Elegant to represent Councilwoman Bell at $400 per hour in the case of Redland Company versus Linda Bell. Authorization up to $15,000, fees and costs.
Thank you. All in favor of motion, please say aye.
Aye.
Any opposed? No. So the motion did carry. I assume that we'll be revisiting this very soon at $400 an hour. I don't think it's going to take long to get to $15,000. I'll turn the chair back over to Mayor Warren.
Thank you, Ms. Warman, for carrying on that task. Let me close the meeting with this comment. When we sit as an elected body and discuss these very sensitive issues, and this is a very difficult issue for all of us, but I want the public to know that each and every one of us, as we sit here representing you, have to make these very difficult decisions each and every day. And they're not easy. Many of them are judgment called based on our research and the information we get from the attorneys and the manager. But I respect each and every one of these elected officials for what they do for the people of Homestead each and every day. And it's not easy. And as Mr. Porter have said, in his 9 years, he's been personally attacked, been through many ethics reviews, so have I, so have Ms. Wallman, and we're currently going through one just from someone saying they dislike the position we took on the issue. So we have to pay legal fees to protect ourselves. I spent $5,000 last year on an ethics complaint, frivolous ethics complaint from a citizen. And many of you don't know what we're going through, but we pay out of pocket for legal representation on these ethics violations. So it is alleged ethics violation. So it's not an easy task when you know you're trying to do the right thing, and because somebody have a difference of opinion, they file a complaint. And then the taxpayer have to bear the burden. It's unfortunate. But I certainly want to thank each and every one of you. It was another difficult call, and I think we made the right decision this evening. And I know I've learned from this experience, and I'm sure many of you, how the fine line we have to walk sometime to get a job done. And we're going to continue to do that. So thank you all so very much for coming out this evening.
Mayor, before we do that, Two items. One is I need to ask for an executive session in the case of City of Brooker versus City of Homestead, and this is a workers' comp case. I'm advising you from the City Attorney's Office that we need to request an executive session. Second of all, I believe I've been advised by Ms. Bell, who would like to make a comment.
Since the vote's already been taken, I just want to make two very quick comments. Number one, when I wrote my articles, it was before we were sued. There was no admonishment or embellishment from the city attorneys not to speak. So it was not a mistake to speak up. Number two, everything I stated in the article was public record. I did not say anything that wasn't public record. It was about the contract, and it was about the votes and how it went, so it was all public record. And I stand that that was not a mistake. It was just simply information that was public record, and that I wrote my articles before the lawsuit. Thank you.
Thank you very much for coming. Meeting is adjourned.